Lawyers, as I have said many times, lawyers tend to be less expensive if you get them involved in the front end. And what I mean by that is if we have the opportunity to help you identify what the actual issues are that you're facing or may be coming down the line because we've gone through that before, we can help people avoid stepping in it, right? One of my favorite sayings is the first rule of holes. I didn't come up with that, but it's when you're in one, stop digging. But you also have to recognize when you're in one, and we can help people identify when they're in one and how to get out of it.
Welcome to Medical Money Matters, the podcast where you can find experts, answers, and resources so that you can achieve mastery over the financial and business aspects of your practice.
Hello, everyone, and welcome to Medical Money Matters. Today's guest is someone who understands that the best legal advice isn't just about helping businesses through a crisis, it's more about helping them avoid one altogether. I am excited to welcome Joe Carlisle, partner at Dunn Carney LLP here in Portland, Oregon. I am delighted that we get to share a lot of clients with Joe, and I am especially glad that I also get to count him as a good friend. Joe is a business and healthcare attorney with more than 2 decades of experience advising organizations through complex legal, operational, and strategic challenges. His practice focuses on healthcare organizations, small businesses, startups, commercial transactions, contract negotiations, and business disputes, giving him a unique perspective that combines both litigation experience and proactive business counsel. What I especially appreciate about Joe's approach is that he doesn't simply solve legal problems after they've occurred. He helps organizations identify risk, negotiate better agreements, build stronger businesses, and make thoughtful business decisions before issues become expensive disputes. That's exactly the kind of trusted advisor every physician owner and healthcare leader needs. Today, we're going to talk about how practice leaders should think differently about working with legal counsel, when to involve an attorney instead of waiting until something goes wrong, and how to build a team of trusted advisors that helps your practice thrive for years to come. Joe, welcome to the podcast.
Oh, thank you for that very gracious introduction. I hope I'm not blushing too much.
You look just great. You look great. So many physicians think of calling an attorney only when something has gone wrong. So what's the biggest misconception healthcare leaders have about the role of legal counsel?
I think what I experience is people are concerned about cost, and I get it, right? Lawyers, good lawyers in particular, can be expensive. So people are trying to balance cost, and I think physicians in particular are constantly barraged with other professionals sort of speaking past them like, oh, you're smart, you understand this. And so I think they feel like they're forced into a situation where I'm smart, I should be able to figure this out on my own, and I'm a business owner, or I'm a business leader. And so that's what my job is, to figure this out. And lawyers, as I have said many times, lawyers tend to be less expensive if you get them involved in the front end. And what I mean by that is if we have the opportunity to help you identify what the actual issues are that you're facing or may be coming down the line because we've gone through that before, we can help people avoid stepping in it, right? One of my favorite sayings is the first rule of holes. I didn't come up with that, but it's when you're in one, stop digging. But you also have to recognize when you're in one, and we can help people identify when they're in one and how to get out of it.
Yeah, that's a great segue for our next question. I do the first rule of holes, so I'm going to write that down. So what are some of the most common legal mistakes you see physician owners make? And not, like you were saying, not because they're careless or uneducated, but simply because they didn't know they should involve an attorney earlier.
Yeah, I think part of it is some of it's being a little bit too trusting, right? Especially because typically people go into a deal expecting the transaction to be harmonious. People do deals in order to make money, right? To further their business interests. And so there are a lot of promises that are made. And so I think it's partly being too trusting. And then what that dovetails with is people not understanding what their agreements actually say and being afraid to ask the question. I think it's a real trap for smart professionals that they feel sheepish about asking and saying and admitting, I don't know what this means, and making a lot of assumptions. And usually those assumptions are that the terms are more favorable for them than the other party, and then just proceeding on that. Because I get a lot of calls from people, whether they're physicians or anybody else who's in business, saying, oh, the other side's saying X, Y, and Z, but it doesn't say that, right? And then when I actually read the document, I say, that's pretty much what it says, but now you've taken a position that doesn't align with what the actual contract terms say. Educating yourself, right? Engaging with a lawyer and educating yourself on what those contract terms mean before you enter into it. And then saving the feedback that you've gotten from your lawyer before you enter into that agreement gives you sort of a roadmap so that if there is a dispute, you have a little bit of base knowledge, or when it's brewing, you have some base knowledge about what your rights and remedies may be under that agreement so that you don't step in it.
Yeah, that's fantastic advice. And I love what you're saying about physicians being well educated and smart and falling into the trap of, I should understand this, as they would be thinking that with contracts and other legal matters. I have a similar experience in going in and looking at financial statements in a medical group and say, the financial statement sings me a song. I look at it and that's my language, and I can look at that and understand a lot about a business. But on the same token, if you hand me an EKG and ask me to read it, I've got nothing. So I think you and I could both encourage physicians to stand in their area of expertise, but then ask professionals when they get into something legal or financial or some other area, not to be so hard on themselves and not to expect that they should always have the answer. I think my theory in talking with a lot of doctors over the years is they kind of get that drilled in medical school. That medical school teaching is very much, you should know the answer because patient lives ride on it. And I think a lot of physicians take that same sort of learning experience into their business and their day-to-day.
And people expect them to be the smartest people in the room.
Mm-hmm. Mm-hmm.
And it may be true depending on what the setting is, right? If it's an exam room or an operating room or whatever, then they better be the smartest person in the room, right? But if it's in a boardroom or in a negotiation, then they need to engage whoever the smartest person is to help them advocate for whatever their interests are.
Yeah, I love that. And that's a great lead in. I would love to have you talk a little bit about the difference between an attorney who simply answers business questions or legal questions and one who truly becomes a strategic business advisor.
Some of it is the privilege that the client gives you, right? When a client follows that advice of, hey, contact me when you have an issue, I am here to be a resource for you, and they follow through with that, then it gives you an opportunity to learn about their business, learn about their goals, the unique aspects of their practice, the things that will drive decisions that you may not otherwise be aware of. And more often than not, for me, I learn about those things when I'm dealing on the litigation dispute side, because I need to get up to speed on how their business operates and those sorts of things, who the key players are, personalities, who's going to be a good witness, who's not, all of those sorts of things. And it's a little bit harder on the transactional side to get a handle on those things. That's why I like my hybrid practice. But you start to, when you have the opportunity to continue to work with clients over time, you start to understand that what their business goals are and who their personalities are, because those things, as I like to say, the answer to most questions, legal questions, it depends on the circumstances, right? I love to say it depends.
Yeah. There you go. You have a hat. You'll have to put it on. So everybody see the hat. Okay, that's good. And for those listening on audio platforms, Joe's hat says it depends. Those are some of his favorite words to answer a question. Begin to answer.
But having that insight, working with clients over and having that relationship developed over time, then when they call you up, you already know the personalities that are involved, whether it's internal or external, whether it's their landlord or an employee or some other entity, vendor that they're working with. And you know that your response needs to be grounded in the law, it needs to be grounded in the facts, but it needs to also be grounded in what their business goals are. And each business and each owner is going to have a different goal. And so being able to tailor your work to that client is really important. I don't know if I've answered the question quite directly, but yeah, that's, I think, the key part is developing that relationship. And to me, the hallmark of that is I have a lot of clients that have my cell phone number programmed in my phone. And those are the clients that are respectful of my time. So when they call me on my cell phone rather than email me, or they call my office number, I know they have an issue, and I will answer their call, right? So I want to make sure that people are taken care of, because it's really the biggest compliment that a client can give an attorney is trusting them with their legal work.
Yeah, absolutely.
So we have to respect that.
Yeah, absolutely. And I love that. I have the same experience with clients who have my mobile phone number too. I know when the phone rings, there's something's happening. And in many cases, something's going to make me go, and then I'm going to say, you need to talk to my friend Joe. Yeah. Well, a lot of the incoming phone calls that I get will make their way to you in some way.
Right. That's true.
That's so great. So thinking about if you were advising a physician who has just become a practice owner, what are the conversations that they should be having with legal counsel kind of during that first year as they're getting started?
Yeah, I think the very first question is, who should I be surrounding myself with? Right? Because I think it's probably true for your work, right? If somebody makes contact with you, then you become sort of their one-stop shop. You're their referral source for who do they need. And the same is true for me oftentimes with my clients is they contact me because they're a new business owner and they say, somebody said I needed a lawyer and they referred me to you. But they're going to need a CPA and they're going to need financial planners. They're going to need practice advisors, right? Depending on what they're going to do, they may need a real estate broker for renegotiating their lease or renewing or moving or finding other space, contractors, architects, all of the support systems that they need to be successful. And I think they don't necessarily have to engage everybody right out of the gate, but it's sort of like you need a plumber. When you need a plumber, you don't want to find out that you have a leak and then open the phone book, right? I'm dating myself, referring to the phone book.
Then do your Google search. Yeah.
You want to have those connections, right? I always used to say, I got a guy for that, right? You need a mechanic, a plumber, an electrician, and all that. You got to have those people in place. So when the need arises, they already have that relationship with you. Yeah. And I think most quality professionals who are especially going to support independent practices are going to be willing to invest some time up front and not expect an immediate return on that. Take lots of calls with people and say, I don't think you need me right now. But when a need arises, I'm happy to help you and work with you on whatever that is. So that would be the first thing I would say is, who are your people? Who are your advisors? And if you don't have these advisors, let me refer you to some people so that, and you have the team that you need in place. So when an issue arises, you're not scrambling, because that's usually when people get themselves in trouble. Is they say, I don't have somebody to go to. I don't know where to begin. I'm going to start Googling, right? And I'm going to start looking for things. And then, it seems simple. I read something. ChatGPT told me this was fine, or whatever it is. And I'd prefer for them to be speaking to human beings with a couple of decades worth of experience.
Some expertise. We could say legal advice is sort of like medical advice. Would you go to ChatGPT for that? So yeah.
Right.
No, that's fantastic. And I would say along the lines of the trusted advisors, if you're working with the right ones and you need another area of expertise, the right ones will be able to refer you to some good ones. Yeah. So no, and that's, you made another important point in there, which is it's reasonable to expect any professional, attorney, accountant, consultant, et cetera, that you might need for your practice would have a first meeting with you gratis, just to get to know you and to make sure that they feel like they can be of assistance to you. And so that's, I think, a reasonable expectation in the marketplace. I share your comment that a lot of times people are afraid to start running up a big bill. And it's like, that shouldn't happen in a first meeting. So
no, really, that person, and they're not investing in you. They're not willing to invest in you.
Right.
And it matters. There are times where it's not going to be a good fit for my practice either. And not comfortable charging somebody for them to find out that it's not a good fit. I think another question that people should be asking is about the firm generally that the attorney's at. You may get a referral to a specific attorney because they have an area of expertise, but I think there's a lot of benefit for keeping your work under one roof, depending on some really big operations have multiple attorneys for various reasons. but I may not be able to do something, or it may be an area of employment law that I don't do much of, right? But I have employment lawyers at my firm, and me understanding the business component and the healthcare aspects of a small practice and being able to walk down the hall to one of my employment lawyer partners and say, I've got a client who has this need, and be able to fill them in. There's a lot of efficiency there. And then the business hand knows what the employment hand is doing, and they're not fumbling past each other, and clients aren't getting charged for twice for having to explain everything. Learning about the firm that the person works at and what their resources are, I think, is helpful. And then asking them questions about what their experiences are with various unique issues that somebody may have experienced already or have heard anecdotally from their colleagues who are also similarly situated, just so you can get a sense, right? We're all marketing, but I think it's helpful to understand what people's actual experience is.
Exactly. Yeah. And the depth of experience is important. And also, to your point, their ability to curbside in the same office. They need it. If they need an opinion. If they need a specialist opinion, can they get that walking down the hall, or is that going to be a referral to another firm? And not necessarily bad if it is, just important to understand. Yeah, there'd be a difference in how you work with them.
Right.
Yeah. Wonderful. You have represented healthcare organizations through both transactions and disputes. And so looking back, what percentage of litigation do you think could have been prevented with better planning, better documentation, better governance? I have a sense you're going to say 100%, but maybe not quite 100%. It depends. Okay, there goes the hat. The hat comes out again.
That's a really tough question to answer. I think I would answer a slightly different question, right? Or give you a different answer. I don't know that it's ever possible to completely avoid a dispute, because so much of that involves personalities. Some of it just involves economic strategy, financial strategy, right? But what I think you can at least narrow the focus of the dispute, and you can better position yourselves by creating stronger agreements, right? If somebody's going to sue because they have a bee in their bonnet, it's very hard to stop that. I respect all my colleagues. The Oregon bar is very collegial and very professional, and it is the outlier that files terrible lawsuits. And I've practiced lots of places, and that wholeheartedly. And it's our client. If our client has a colorable argument, then it's our obligation to take that argument to the fullest extent. So you might be able to shut down some arguments. You may be able to stop them in their tracks earlier instead of having to go the distance by having better agreements. That's where, if you pay for it on the front end and you have a fulsome agreement that you understand, that has all the deal terms, instead of relying on, oh, trust me, we'll take care of you.
Or the handshake or whatever.
Yeah, then you can head that off. I think the other part of it is making sure that from the lawyer's perspective, making sure that clients understand their agreements, right? Mm-hmm. And then from the client's end is understanding your agreements, right? And taking notes, asking your lawyers for synopsis of what these things mean, so you have a cheat sheet to go back to understand it. Because I think that's where a lot of disputes arise, is people get fuzzy on the actual details of their agreements, and they think they have more rights and remedies than they actually do. And then once the dispute has started, it snowballs, and it's hard to unwind things.
Yeah. No, that's great. And a great reiteration of the invitation to just stop and say, hey, I don't really get this part, or I don't really understand what that means to me or my business. And can you walk me through that? Explain it to me. Give it to me in English, not legalese, please. Can you give your patient all the information in English and not medical speaks? Yeah, it's fair. I think it's very fair to ask for translation, same as you ask your CPA. Explain to me the tax ramifications of this in a way that I can understand it. That's great. Yes. Thinking a little bit about, as we're talking about physicians and healthcare leaders, and sort of back to this trusted advisors, if a physician is working with an accountant, a banker, a consultant, financial advisor, somebody in insurance, and an attorney, what would you say about how all those professionals should work together, and what role the physician should play, or their leadership, their executive leadership should play in coordinating that team?
Yeah, that's a great question. At the end of the day, the client is the client, so they're the ultimate decision maker, and that's tricky, right? Because they're the decision maker who is relying on the professional, so it becomes a little bit circular there.
Yeah,
We're
sure.
advising you, but hey, it's your decision. But I think understanding what the parties' roles are, another favorite saying of mine is, I'm not a tax attorney. I can identify that there's probably some tax issues in a transaction, and I refer people to CPAs. If they don't have one, I have several that I work with, and I like, because fit matters.
Mhm.
I like to refer people to different professionals and allow them to develop that relationship. And then we can have communications, and I can be directing the client or working directly with the CPA on what does this mean, right? And it could be as simple as entity formation, right? Talk to your CPA about what the tax treatment is going to be for your type of business. They can help you understand what kind of entity will give you the best tax treatment. You can come back to me and I can help you form that entity. That's an easy example. Or if you're redeeming a shareholder or a partner or somebody in your practice, how do we deal with the tax treatment of those sorts of issues, right? And then you have the coordination there. Or if it's a broker, then we're going to need to look at the lease, right? They're going to help you with the deal terms, but the nitty gritty details about your rights and remedies under that lease are going to be something for a lawyer to review. And if the broker and the lawyer have a relationship already, then it eases the communication, because the broker wants to get the deal done, right? The client wants to get in the space and start doing business, and the lawyer wants to protect them. And so having those relationships allows the broker to know that the lawyer is trying to protect the client, not kill the deal, right?
Yeah.
And they can work together instead of at cross purposes.
Yeah, that's fantastic. One of my friends used to say that he knew lawyers who were deal makers and lawyers who were deal breakers. And that was his story. It was a dichotomy.
Yeah, I deal with those too. But that goes back to relationship also, right? Is every client has a different risk tolerance, and knowing whether somebody is willing to walk away from a deal or not, and what are their core terms, allows the lawyer to say, hey, I typically push back on this. It may get rejected, or you might have a narrow window on this space or whatever it is. So you may not want to push that hard on this because this is really crucial to your long-term plans, right?
That is the art of the deal. Yeah. And understanding, the risk tolerance. And in general, most physicians that I've worked with over the years tend to be fairly risk averse. And I think to your earlier point, sometimes they sign things without really understanding fully they set themselves up for a lot more risk than they thought. And so or than they might have chosen if they were fully aware of their terms and all of that. So yet another reason to really pause and say, hey, could you translate for me here? Because I like to say that when we're speaking finance, it's like speaking Swahili. Could you please say that in English? Yeah. And it's a perfectly legitimate question to ask. So that's so great.
Yeah. I think sometimes people will say, I didn't see the downside to it, or phrases similar to that. My response is, then you weren't thinking creatively enough.
Yeah, exactly.
Anything could go wrong, right?
Exactly. Let's figure out what could go wrong.
Yeah.
No, and that's a particular lens and a particular challenge it's a skill as well to be able to look through that lens and say, what could go wrong with this agreement? A little bit like physicians, if they're recommending a different medication, what could go wrong? What could go right? And what could go wrong here for this patients? Pretty holistic way of thinking about it. And I know if you're anxious to get a deal done, it can feel a little frustrating sometimes. So you have this advisor that's coming back and saying, yeah, but, or it depends. So yeah. I love it. You got to just lean into the yeah buts, because that is all about the attorney trying to work with you and represent you, help you make good decisions.
Yeah. And sometimes I try to say yes and.
Yes and rather than yeah but.
Yeah. It's a positive version of yes but, yeah but.
I love that. I like it. Yes and is perfect. Let's shift gears a little bit and talk about contracts. You mentioned that earlier, and there's so many different contracts inside of each medical practice. So we've got employment agreements, got vendor relationships, leases, payer contracts. So what advice do you have for leaders about negotiating agreements instead of just simply signing what's presented to them?
The starting point is always, where is your leverage? What kind of leverage do you have? And where are the red lines for you? What's the deal breaker terms, if there are any? And providing your advisors with that information is really crucial, because it's rare. Every now and then I see them, but it's rare that anybody sends you a contract that is going to be favorable to you. Right. They're paying somebody to write the contract to be quote unquote reasonable, commercially reasonable, but with terms that are going to be more favorable to the drafter. Right.
Yep.
And so whether it be a lease or a payer provider contract or an employment agreement, whatever, the goal is to protect parties. And I think the way to look at contracts are not just about, we have a deal, but where the risks are shifted, where they land within that deal. Right? The deal part is easy. Like on a lease, you're going to get 1,000 square feet and you're going to get it at whatever, $30 a square foot or whatever it is, right? And for X number of years. That part's super simple, but there's a whole lot that goes into who's going to pay for all of these other things, right? And what if this happens? And what if that happens? Who's going to bear the risk of that? And what insurance are you going to have? All those sort of risk shifting mechanisms, right? And it's paying attention to those that are really crucial, and being aware that they exist, being aware that you may have some leverage to push back on that, but it depends on how you're situated, right? And so if you have extra time on your lease and you've got all the time in the world to work with a prospective landlord, then you may have some leverage. Or if you're moving to a part of town that has low tenancy right now, low occupancy right now, you may have some leverage there.
Yeah.
If your lease renewal is coming up in the next year or so, right? You might have some leverage to get some better tenant improvement allowances for your renewal period so that the landlord doesn't lose you, right? In a year where the occupancy is very high, right? You're not going to have that same kind of leverage, right? In healthcare with your payer provider agreements, right? They used to say there was only 100 pennies in a dollar, but apparently we don't have pennies anymore. So there's only 20 nickels in a dollar. And you can only squeeze 20 nickels out of that dollar. And everybody's trying to squeeze as many nickels out of that dollar for themselves as possible. But you have to keep your network going, right? You need to make sure that you do have those payer agreements so you can get paid. And so figuring out where your leverage is and where you're located too. I think the payer market in Oregon is different than Washington or California, or certainly the Midwest and the East Coast. So where you're located is it's going to depend on where you're located.
Depends,
So those are the kinds of things, and understanding where those risks are and where those leverage points are going to be, and asking your advisor, not just is this standard, just because it's a standard term. I find when I'm negotiating and I hear, oh, that's standard language, we have that in all of our agreements, that doesn't mean anything to me. It means it's common, but you can put, as long as it's not illegal or runs afoul of regulatory compliance, you can agree to anything, right? So that to me is a cop-out. So asking, is this common? It's a good question, right? But that doesn't mean that it's fair to you, right? Instead, it's common for the other side to try and shift the risk to you. The question, is that a risk that you're willing to bear? And if it is, then the next question is, what can we do to mitigate that risk on our end if something happens? Is there insurance for that? What does that insurance look like? And is that a cost that is worthwhile, right? Or is there some middle ground that we can reach to push some of that risk back, right? It doesn't have to be an all or nothing game.
Yeah, no, I love that. And I love thinking about sort of risk on a continuum. Usually also there's expense continuum too. How much will you have to pay to sort of buy down that risk, whether you do it with an insurance product or whether you do it with a service that's outsourced, or you do it with a workflow or a policy or whatever. The
one thing I'll say on the vendor side, depending on what kind of vendor you're talking about, I think those contracts tend to be more traditional boilerplate. They're harder to negotiate. And those are the ones where you really want to be paying attention to the automatic renewals. You want the termination
Term and
term,
termination. Yeah.
notice provisions. I think
Yep.
there are some real nuts and bolts. Partner of mine and I, we gave a presentation called "Don't Get Burned by the Boilerplate," and that was in the real estate context because so many people are like, "Oh, nobody reads that stuff."
Yeah.
That doesn't mean it's not enforceable, right?
Yeah.
You
Yeah.
sign after all of the
You're signing it.
boilerplate,
Yeah.
so understanding what it means is really crucial. And you can terminate a contract but not give the notice in the right way, and then that becomes a mess. And then did you terminate it? It automatically renewed. Then they say you owe for the duration of it. There are a lot of traps out there. So understanding what those are.
Beware the linen contract. Those are the ones for me. I won't name the name of the company, but they do all the gowns, and they always had just 5 years, 60-month terms as boilerplate. And back in the day when they handed me a paper contract, I would always strike the 60 and just write 12. And they would actually sign them with me. But yeah, we've had that come up with practices that were dissolving. The physician wanted to retire, and they had a contract that well exceeded their retirement date for a copier or linen, or it's these service things you don't really think about. And perhaps your office manager has filled that out, but good to have a listing of your contracts, your contractual obligations somewhere in a file.
Yeah.
So that
and this is so down in the weeds, but I think it's kind of indicative of what you should be expecting out of your advisors too, is to help point out these are the things that drive people nuts and cause them to get in these fights that are messy. There are simple solutions to that, right? If you know what kind of notice you have to give to terminate a contract, and put it on your calendar. If it's 90 days, put it on your calendar 180 days out. Start asking your staff, right? And your staff will tell you, oh my gosh, that vendor X is terrible for all of these reasons. And you had no idea because you were doing your profession, you were doing your craft, and you're not at the copier or dealing with the gowns or whatever it is. And the lab, all the other ancillary services that have those types of agreements. And your staff hasn't told you that because they're like, that's who you signed up with, right? And then if you ask their opinion, they're like, oh, they're terrible. And then you have a window to terminate that agreement and have a window to get somebody else in place, right? So that you have seamless integration of one service to the next, right? It's super simple. You just put it on your calendar. Right?
Yeah, no, that's an excellent point. One of the things we do with groups as we're working with them on their payer contracts is get one-page contract matrix. Let's get those all organized. So you see all the terms in one place. You can see all the payers. You can see all the rates next to each other. And that brings me to a notion that sometimes you're negotiating, and one of the options that isn't always abundantly clear is that maybe you don't have a contract anymore. Maybe you cancel. You go out of network with the payer contracts or with a vendor. Like you say, if there's a vendor that's terrible, you don't need to renew. You can find a new one. And with payer contracts, maybe that's not a payer you want to be in business with. I think a lot of people feel like we have to take contracts with all the insurers in the area. The answer is no. If they have a high administrative burden, that's a great information you can get from your team too. If you ask your billing team, how is it to work with XYZ insurance company? They're a pain. They always request chart notes or they deny a bunch of claims and we have to go rework them all. But that's, again, to your point, they may not give that feedback to the physician.
Yeah.
It's great to ask.
Yeah, I think I guess I would amend my earlier statement is also surround yourself with good people internally and then rely on them, ask them questions.
Yeah.
Right.
Yeah.
And because same is true with me, my assistant and my paralegal, I don't know what the document vendor, what they're like to work with or a court reporter or whatever.
Yeah.
Right? They handle all of that and they can tell me like, oh, they're terrible.
Yeah.
Okay, why are we paying them?
The good, the bad, and the ugly. Yeah, I love it. I think you and I could continue talking legal for hours on end, but I want to make sure we wrap with my favorite closing question, which is, if you could give every physician owner listening today one piece of advice that would save them significant time, money, stress over the course of their career, what would it be?
Well, I'm going to be a little bit of a broken record, but God, just one piece of advice. I would say
that's limiting. Yeah. Hey, you could have two.
I would say then hands down more than anything is understand all of your agreements. right? And I mean that top to bottom, whether it be your lease or your any sort of practice loan, right? Or your operating agreement or your bylaws, your shareholder agreements, all of those sorts of internal agreements. I think having an understanding on all of those are your core business terms. Everything runs off of that, and understanding what the terms are, your obligations and your rights and remedies under those is just crucial for you being able to then direct traffic with the rest of your team, because you are giving them directions that are grounded in the actual terms of those agreements, rather than giving them a business goal that doesn't necessarily dovetail with the actual terms of the agreements that you signed.
Fantastic advice. Joe, I can't thank you enough for being with me today and everything you've shared with our audience. So appreciate it.
Oh, it's my pleasure. And it's always a joy just to have this kind of conversation with Jill.
Thank you. Thanks, everyone. Before we wrap up, if you've ever felt frustrated trying to understand why you're being paid a certain way or how to improve it, you're not alone. Contracting and credentialing are two of the most overlooked and frankly misunderstood parts of running a medical practice. But they have a direct and lasting impact on your revenue, your access, and your overall financial health. At Healthy Practices, we help physicians and medical groups navigate both payer contracting and credentialing with clarity and strategy. On the contracting side, that means understanding your current agreements, identifying opportunities for improvement, and negotiating from a position of knowledge, not guesswork. Because even small changes in your contracts can have a significant impact on your revenue over time. And on the credentialing side, we make sure providers are enrolled correctly, efficiently, and without unnecessary delays, so you're not losing revenue simply because of administrative bottlenecks. This is one of those areas where things often, quote, seem fine until you take a closer look and realize there's real opportunity on the table. So if it's been more than a year or two since you've renegotiated your contracts, or you're just ready to better understand your contracts, clean up your credentialing processes, and make sure your revenue is truly aligned with the care you're delivering, I'd encourage you to reach out. You can learn more and get started through the link in the show notes or at healtheps.com.